5 seconds to go. Start. It has been held that the state is duty bound to protect the group from such assaults, and if it fails to do so, it will fail to perform its constitutional as well as statutory obligations. It has been held that the state government must act impartially and carry out its legal obligations to safeguard the life, health, and well being of Chakmas residing in the state without being inhibited by local politics. In Justice K.S. Puttaswamy retired and another versus Union of India and others, while dealing with the constitutionality of the Aadhaar Act 2016, this court held as the interpreter of the Constitution, it is the duty of this court to be vigilant against state action that threatens to upset the fine balance between the power of the state and the rights of citizens and to safeguard the liberties that inhere in our citizens. In his dissenting opinion, Dr. Justice D.Y. Chandrachud, as his lordship then was, described the principle of the rule of law as under. The rule of law is the cornerstone of modern democratic societies and protects the foundational values of a democracy. When the rule of law is interpreted as a principle of constitutionalism, it assumes a division of governmental powers or functions that inhibits the exercise of arbitrary state power. It also assumes the generality of law. The individual's protection from arbitrary power consists in the fact that her personal dealings with the state are regulated by general rules binding on private citizens and public officials alike. This sentiment was echoed in Roger Matthew versus South Indian Bank Limited and others, where this court held if rule of law is absent, there is no accountability, there is abuse of power and corruption. When the rule of law disappears, we are ruled not by laws but by the idiosyncrasies and whims of those in power. Again, earlier this year in Bilkis Yaqub Rasool versus Union of India and others, the concept of the rule of law was discussed in detail. It was held rule of law means wherever and whenever the state fails to perform its duties, the court would step in to ensure that the rule of law prevails over the abuse of the process of law. Such abuse may result from inter alia inaction or even arbitrary action of protecting the true offenders or failure by different authorities in discharging statutory or other obligations in consonance with the procedural and penal statutes. Breach of the rule of law amounts to negation of equality under Article 14 of the Constitution. The concept of rule of law is closely intertwined with adjudication by courts of law and also with the consequences of decisions taken by courts. Therefore, the judiciary has to carry out its obligations effectively and true to the spirit with which it is sacredly entrusted the task and always in favor of rule of law. There can be no rule of law if there is no equality before the law, and rule of law and equality before the law would be empty words if their violation is not a matter of judicial scrutiny or judicial review and relief, and all these features would lose their significance if the courts do not step in to enforce the rule of law. Thus, the judiciary is the guardian of the rule of law and the central pillar of a democratic state. Therefore, the judiciary has to perform its duties and function effectively and remain true to the spirit with which they are sacredly entrusted to it. Further, in a democracy where Rule of law is its essence. It has to be preserved and enforced, particularly by courts of law. Compassion and sympathy have no role to play where rule of law is required to be enforced. If the rule of law has to be preserved as the essence of democracy, it is the duty of the courts to enforce the same without fear or favor, affection or ill will. It is thus well settled that the rule of law has been described as a safeguard against the arbitrary use of the state power. It ensures that the actions of the government and its authorities are governed by established legal principles rather than arbitrary discretion. Whenever the citizens, in the form of mobs, have broken the law to vandalize or to declare threats, the court has cast an obligation on the state to prevent such threats or assaults. This obligation underscores the state's responsibility to maintain law and order and protect citizens from unlawful actions that undermine the rule of law itself. It is not necessary to state that failure to uphold these obligations can erode public confidence in the justice system, leading to an environment where the rule of law is compromised by lawlessness. Ensuring the preservation of the principle of rule of law and the protection of the civil rights and liberties of citizens is essential for protecting the constitutional democracy. The concept of the rule of law is not an abstract principle but is reflected in the substantive content of various legal domains. In this regard, it would be apt to refer to the following articulation of the rule of law. The rule of law provides a framework and value system in which institutions, principles, and rules are implemented to rein in the arbitrary exercise of state power and to prevent the abuse of power, to ensure predictability and stability, to make sure that individuals know that their lives, their liberty, their property will not be taken away from them arbitrarily and abusively. It is from this core of understanding that constitutional law, criminal procedure, due process, equal protection, international law, the laws of war, and human rights law find their moral, ethical, philosophical, and political justification in controlling the actions of executive power. It has been emphasized that the rule of law provides a framework and value system to rein in the arbitrary exercise of state power and to prevent the abuse of power, to ensure predictability and stability, to make sure that individuals know that their lives, their liberty, their property will not be taken away from them arbitrarily and abusively. It can thus be said that the processes enshrined in constitutional law, criminal law, and procedure are facets of the rule of law and thus serve to regulate the exercise of executive power. Another important aspect that needs to be addressed in the present matter is with regard to the doctrine of separation of powers as envisaged in our Constitution. Our Constitution has earmarked separate areas for exercise of powers and for discharge of duties to the three organs of the democracy, viz., the executive, the legislature, and the judiciary. The legislature is empowered to enact the laws within the framework of the Constitution. The executive is entrusted with the powers and is expected to discharge its duties in accordance with the provisions of the Constitution and the laws as enacted by the competent legislature. The adjudicatory function is entrusted to the judiciary. In several judgments, this court has reiterated the principle governing the separation of powers. stove.